All right, good morning, ladies and gentlemen. Deputy in courtroom 2, are we ready to proceed?
Yes, Your Honor.
Okay. Good morning, my name is Judge Law, and we're going to address the state all-purpose calendar with the State Court of Fulton County for today, May 2nd at 9 a.m. These are cases in which individuals have already been arrested and accused of certain misdemeanor offenses. If you have already consulted with an attorney, please remember that we're going to proceed with today's calendar with regards to inquiring about the status of your cases. Either you've considered a plea offer from the prosecutor and would like to consider entering a guilty or no contest plea to the charges or reduced charges. And also, if you want to enter a not guilty plea and have your case scheduled for trial. In either event, please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and if you cannot afford one, one will be appointed to represent you. Ms. Vigiletti, good morning.
Good morning, Judge.
And the one thing I haven't yet printed was the announcements. Have we got a complete list yet, or?
Yes, Your Honor. I sent an updated one along, but I'm happy to forward.
Oh, no, that's quite all right. I'm sure I have it. I just wanted to make sure we had a complete one. Okay, and who do we have next to you right now?
Position number 17, Raymond Russell.
And how are we proceeding on this case?
Mr. Russell would like to enter a plea today.
All right. And our prosecutor is Ms. Desiano. Oh,
Good morning, Judge.
Good morning, good morning.
I'm sorry, could we repeat his name? You said, is this Russell?
Position 17, Raymond Russell.
Thank you.
Okay. And Mr. Raymond Russell, my name is Judge Law, and please remember that your right to remain silent and your appointed counsel is Ms. Vigiletti. This is going to be a plea hearing with regards to your case 22 CR 7541E, in which you are accused of criminal trespass and willful obstruction of an officer from November 1st, 2022. May I place you under oath, Mr. Russell? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Desiano, what's the offer, please?
Yes, Judge, the state recommends on count 1, 12 months probation, serve 94 days, credit for time served 47 days. That would be from November 2nd to November 4th, 2022, and then March 20th, 2024 to today. Balance suspended. Stay away from the Chevron located at 1217 Metropolitan Parkway Southwest. Count 2, time served 94 days, credit for time served 47 days, concurrent with count 1. And I would ask the defense to stipulate to the venue, factual basis, and identification for purposes of the plea.
First, if I may just clarify, a suspended balance doesn't have probation, right?
Right, balance suspended is no probation. It's basically a time served.
Right, and that was our understanding as well. And we do so stipulate to the 3 required elements for the purposes of the plea.
Thank you. Mr. Russell, have you consumed any medicine or alcohol?
No, ma'am.
Have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your counsel?
Yes, ma'am.
Is anyone forcing you or giving you inducement to enter into this plea?
No, ma'am.
If you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get the opportunity to go back to court, have the assistance of counsel to confront your accuser, challenge the evidence brought before you, present your own defenses and arguments, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of criminal trespass and 1 count of willful obstruction of an officer?
Guilty.
Your sentence for the trespass is 12 months to serve 94 days, credit for time served 47 days. Your jail time is concluded. The remainder of the time is suspended. And with regards to the willful obstruction of an officer, it is time served. In other words, to serve 94 days, credit for time served 47 days. If you have no other cases holding you at the jail, you should be released within 24 hours. However, if you return to the Chevron located at 1217 Metropolitan Parkway, Southwest Atlanta, well, all I can say is that will roll out the red carpet for you because you'll be arrested again. Thank you.
Your Honor, also, I'll add, I'm seeing that he may have an FTA associated with this case that wasn't on the calendar.
Yes.
It was case number 24 FTA 304. I'm gonna get with Ms. Falk and confirm if that FTA is still active, and if so, we'll not process that.
Well, let me go ahead and find out right now.
Okay.
You said it was 24 FTA 0000304. Yes, it's still an active FTA. If you could please submit the null pros for that specific matter as well. So
Yeah, sure.
the bench warrant is null pros. And that concludes the case. Thank you.
Next, we can go to position number 20 and 21, Mr. Henry John Ware. Wow.
20 and 21, this is going to be a negotiated plea on the main case and a null pros if possible on the FTA. This is State versus John Henry Ware. Case 22 CR 7464J involves 5 charges, beginning with possession of marijuana less than 1 ounce, driving while license suspended or revoked, possession and use of a drug-related object, failure to use a signal lane change or turn, and a legal stop or standing where prohibited. This stems from a February 10th, 2021 incident. Mr. Ware's second case is a bench warrant for failure to appear in court, and that's 24 FTA 486 from a February 5th, 2024 incident. Mr. Ware, you have been advised of your right to remain silent, and your attorney is Ms. Vigiletti. Ms. Vigiletti, this is going to be a negotiated plea. Would that be correct?
Yes, Your Honor.
Mr. Ware, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Desiano?
Yes, Your Honor, the state's recommendation is count 1, null pros, count 2, 12 months probation, serve 86 days, credit for time served 43 days. That's from February 10th to March 16th of 2021. And then April 25th, 2024 to today, balance probated, a $2,500 fine, a 1-year license suspension. On count 3, 12 months probation concurrent with count 1. Count 4, 12 months probation concurrent with count 1, and a $265 fine. Count 5 would be time served, 86 days, credit for time served, 43 days from the same dates. And then the FTA would be null pros upon entering the plea.
Okay. Is there a particular reason why that fine is $2,500?
For,
Driving while license suspended or revoked? Is this a multiple offense?
yes, Your Honor, he has several convictions, and he has, I believe, 3 or 4 open driving while license suspended.
All right. Thank you.
At this time, I'd ask the defense to stipulate to the venue, factual basis, and identification for purposes of the plea. Nothing further.
So stipulated. We did want to ask this morning, Your Honor, because the fines are quite high. They total $2,765. If you would be willing to either assist Mr. Ware with probation fees, or perhaps terminate or make his probation non-reporting upon payment of the fees, because the fees are the only requirement here for probation.
I will waive the probation fees for the months of May and June. Does he have any holds?
Yes, he actually has a hold in Washington County, Florida.
And what's the charge?
I can't see the charge. I don't know if perhaps Ms. Tyson knows.
Pre-trial, do you have that information? So,
Good morning, Your Honor.
good morning, Ms.
Okay.
Tyson. Yes.
Looks like it's a, let's see. No, I don't have anything. The only thing showing up on the GCIC is the failure to appear from Fulton County,
Okay,
so I can't see it. Yes, Your Honor.
From what I can see, Judge, he has several open cases. It might be one of these. There's a driving on a suspended, giving false name, DUI, drugs, and possession of marijuana open in Seminole County, Florida. There's also one open in Colquitt County for driving on a suspended, theft by shoplifting, false statements. And there's another one that's open in Decatur County that's possession of marijuana with intent to distribute, possession of drug-related objects, and possession of cocaine with intent to distribute.
okay. It looks like, Ms. Vigiletti, he is, quite an individual in demand in several jurisdictions. So at the present time, all I can do is waive probation fees for 60 days, the initial 60 days. But after that, he must report every month. He has to surrender his driver's license either to the, well, I don't know where his driver's license is, but if he's in possession of one, it has to be surrendered to the probation officer. And then he will report every month. He will be subject to alcohol and illegal drug screens. And he will start paying his fine with the initial payment being $500. And then a payment of $250, minimum payment of $250 every month thereafter. And that's the only way that I can assure that Mr. Ware complies with the probation requirements, since I'm not too confident about him doing otherwise.
Understood, Judge. And because Mr. Ware is going to be extradited to Florida, is it possible, may I just write 2 months of fees waived rather than specifying May and June?
No, he has to come back to Fulton County. We will hold his probation here, and then he has to come back to Fulton County.
He possibly won't be released by June because we don't know what the charge is.
We'll wait.
Yes, so when we're talking about waiving fees.
Yes, you put in there that his first 2 months of probation fees are waived.
Understood, thank you.
I'm not sure he's gonna make a dent. He's got almost $3,000 in fines to pay. All right, and absolutely no driving. So, are we still proceeding, Ms. Vigiletti, with this plea?
Yes, Your Honor.
Okay. So, I don't know where I stopped at, but, basically, Mr. Ware, if you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not be able to, confront your accuser, challenge the evidence brought before you, and have the state carry its burden and prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of driving while license suspended or revoked?
Yes.
How do you plead to one count of possession and use of drug-related objects, failure to signal lane change, and illegal stop or standing?
Yes.
Right? On the driving while, on the possession and use of drug-related object, that's going to be 12 months concurrent with count 2. On the failure to signal a lane change, that's going to be, that's going to be 12 months concurrent with count 2 plus a $265 fine. On the illegal stop or standing, that's going to be time served 86 days, credit for time served 43 days. Going back to count 2, the driving while license suspended or revoked, your sentence is 12 months to serve 86 days, credit for time served 43 days. Once you have resolved all your holds, wherever they may be, you have to return to Fulton County and start your probation. In this particular case, you will immediately report to the Fulton County Probation Office at 132 Mitchell Street. While you're on probation, your probation fees for the first 2 months shall be waived. Your fine will be $2,500 plus a mandatory 1-year license suspension. You're not eligible for any reinstatement for a minimum of 12 months as far as this case is concerned. I don't know how your disposition of your other cases may affect the status of your license. For this case, the 12 months begins from the time that you begin probation. It doesn't begin from today. It begins from the time that you start probation. So your total fine is $2,765. In the first month of reporting to probation, you will pay a minimum of $500 for the fine. Thereafter, you will pay a minimum of $250 every month. No driving, no alcohol, and no illegal drugs. You will be subject to random screens. Thank you.
Thank you, Judge.
You can have a seat. Next, we will go to position number 5, Mr. Thomas Colton.
Oh, and with regards to position 21 on Mr. Ware, that will be null crossed.
Thank you, Judge.
This is Thomas Colton. We're charged with criminal trespass from April 17th, 2024, case 24 CR 2017E. Mr. Colton, you've been advised of your right to remain silent, and you're represented by attorney Mr. Michael McLean. Good morning, Mr. McLean.
Good morning, Your Honor. Finally, glad to make it here.
No problem. And so how are we proceeding in your case?
A negotiated plea, Your Honor.
All right. Mr. Colton, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Repeat.
Yes, ma'am.
Thank you. All right. Good morning, Ms. Fall.
Good morning, Your Honor.
And how are we proceeding with Mr. Colton?
My understanding that it is a negotiated plea, but let me just double check.
I didn't know if something, I need to go back and look at it. I suppose it's the liquor store or package store. And there is an anti-theft course involved. I didn't know if something was taken, but I did look at it about a few days ago.
Yes, it says negotiated plea. So that is my assumption for what we are doing here today. I just checking back with Mr. McLean, is that still your position?
Yes.
Okay, so the recommendation is 12 months serve, 32 days, credit for time served 16 days, April 17th, 2024 to today. Balance probated, stay away from 2110 Campbellton Road, which is the Southwest Package Store. No further contact with Mr. Sung Wei Hoon. 40 hours of community service, anti-theft course. We did reach out to Mr. Sung Wei Hoon and would like to sound for him to see if he is in court today and would like to speak. And we ask that the defense stipulate to venue, factual basis, and identification for the purposes of the plea.
We do.
Mr. Sung, are you on the Zoom? This is your chance to contribute to the proceedings. All right, he's not. Mr. Colton, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Is anybody forcing you, inducing you to take this plea today?
No, ma'am.
Are you satisfied with I don't know if I asked you this. Are you satisfied with your counsel?
Yes, ma'am.
All right. If you decide to enter this guilty plea, you would have to give up your constitutional right to a trial.
No.
All right. There's a young lady in a bathroom on iPhone. Could we please stop her video? Thank you. All right. As I was saying, if you decide to enter this plea, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have an opportunity to go back to court with your lawyer to confront your accuser, challenge the evidence that could be brought before you, present your own arguments and defenses, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass from April 17th at the Southwest Package Store?
You.
Your sentence is going to be 12 months to serve 16 days. No, excuse me, serve 32 days, credit for time served 16 days. If you have no other cases holding you at the jail, you should be released within 24 hours, but you will need to report to the Fulton County Probation Office on Monday. That is at 132 Mitchell Street in downtown Atlanta. You must report there before 3 p.m. And while you're on probation, you shall stay 200 yards away from the Southwest Package Store at 2110 Campbellton Road. You shall have no contact with the employee or owner, Mr. Sung Wang Yun. You shall complete 40 hours of voluntary community service, beginning with a minimum of 5 hours per month, beginning with the first month. You can do the community service at any nonprofit agency that's not a church and not a school. And you shall complete an anti-theft class. That class must be completed within 60 days of being released from the jail. You will report to probation every month, and if you get arrested again, or if you violate the conditions of your probation, probation is authorized to revoke and request that you serve out the rest of the time in jail. That concludes your sentence.
Next, we go to the probation revocation calendar, position 1 and 2.
Okay.
Probation one.
Is,
He's in quorum 2.
all right, thank you. We are addressing Shaquille Perry, who's got a probation revocation matter, case number 22 CR 4405A, in which he was convicted of battery family violence. The probation revocation case is 24 PV 000711. Mr. Perry, you've been advised of your right to remain silent, and your attorney at the present time is Ms. Vigilante. Officer Allen with the Fulton County Probation Office, good morning. If you could please unmute your Zoom. Thank you.
Sorry.
No
Good
problem.
morning.
Officer Allen, good morning. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. All right, we have Shaquille Perry. When was he convicted and what was he required to do, and why are we seeking a revocation?
Your Honor, Mr. Perry was sentenced to probation. Give me 1 second, I'm sorry. He was sentenced to probation September the 12th, 2022, where he was charged with the offense of battery, family violence. He was required to complete the domestic violence program, have no violent contact with Jasmine Dix, as well as stay away from the incident location. The defendant reported 2 times to probation. He has failed to provide our office with completion of the domestic violence program. It is 44 days remaining on his case. He has been in custody since April 24th, 2024. At this time, probation recommends his balance be revoked.
All right. And since April of, I'm sorry, what? So I'm just trying to figure out whether it's at least 22 days.
Judge, I believe that he has 36 days remaining. And I can give you the full math on that if you'd like.
Sure.
He received credit for time served 67 days upon his conviction. He was convicted on September 12th, 2022. The violation warrant was entered May 23rd, 2023. So that period of time is 253 days. And as of today, he's been in custody for 9 additional days. So 67 plus 253 plus 9, I believe, is 329.
All right.
And Your Honor, that is with the credit, if we decide to give him credit or you decide to give him credit for the time he's been in custody.
Okay. Let me see. Ms. Tyson, with regards to Shaquille Perry, have there been any arrests or convictions since September of 2022?
One moment, Marilyn, let me check. You said September of 2022?
Yes. In any other jurisdiction?
He had a FTA out of, let's see, Clayton County. And that was April of 2024. and he had a battery.
Is it possible he was here? I'm sorry to interrupt. I'm just.
That's okay.
For that.
Yeah, I'm considering that. And the battery, additional battery charge?
That's the, no, that looks like it's the battery charge that's on the calendar from July. So the battery from July that's on the calendar, and then the FTA out of Clayton County from this year. That's it.
Okay.
Judge, Mr. Perry tells me that Clayton County is where he came from and that case was dismissed.
Good, good. I'm glad to hear that. Mr. Perry is going to serve an additional, I'm going to revoke his probation. This is going to be marked as a probation violation, and he's going to serve a full 18 days. I'm not going to give him credit 2 for 1. So he's going to serve the remainder of 18 days, 2 for 1, for failure to complete his requirements on a sentence of battery family violence. He's only reported twice on probation, which is a crying shame since he was required to report every month. He was required to do a 26-week program that we impose upon anyone who's convicted. And I'm not going to exclude Mr. Perry as a special case. And he failed to complete the program. Based on these blatant disregards of the requirements of his sentence, he's going to serve an additional 18 days at the Fulton County Jail, day for day.
Judge, if I may, just for the record, I did speak to Mr. Perry for quite a while about him stop reporting for probation yesterday, and he said he was having a very difficult time finding a job, and his probation officer said, hey, next time you report, if you don't have a job, I'm arresting you, and he was afraid to report. And one thing I always tell my clients is even if you don't have a job, even if you don't have money, just keep reporting. And I don't believe that is what he was told. He does have 2 children. He is doing HVAC work. He has an amazing training opportunity coming up to move up in his training. And I just wanted to put that information on the record.
All right. Ms. Allen, is there anything in the record that he would be subject to an arrest for failure to retaining employment?
No, Your Honor, I'm reviewing the notes right now, and that is not a practice that none of my office should be saying, or to say they have the power to arrest anyone, because we don't have that power.
All right. The request is denied. 18 days, day for day.
Thank you, Your Honor.
Next case, and I guess this was addressed 4 cases. Next case, please.
No.
I'm sorry, Deputy, could you repeat that? Jail court iPhone? Was that?
Yes, yes.
All right, and who do we have?
That on position number 1.
Okay.
Mr. Law.
Is is the gentleman all right, or is he about to pass out?
No, he's all right. He's just come on, man, knock it off. All right, man. No,
I can address you next week if you don't know how to behave properly. I can address you next week if you don't behave.
All right, man.
Thank you. I beg your pardon?
We got some inmate issues going on here.
I hear you, bud.
This is Andrew Todd Long, accused of criminal trespass in case 23 CR 6733H. Mr. Long, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean.
I already chose to represent myself in court.
Your Honor, he tells me he wants to be pro se.
All right, I didn't know that. All right, so now we've been informed of that. Mr. Long, if you decide to waive your right to counsel, you are responsible for any legal decision that you make, and you are assumed to understand the laws and the criminal procedures as they apply to the facts of your case. Would you still like to Would you still like to waive your right to counsel, or would you like to be represented by an able, competent attorney from the Public Defender's Office?
I choose to represent myself in court.
All right? Please stand up.
Right to-
Please stand up. All right. Thank you. You are accused of criminal trespass from October 26, 2023. And the state has made a proposed offer of 12 months to serve 24 days, credit for time served 12 days. And if you accept that offer to plead guilty to the charge, you'll be required to stay away from the Medical Arts Building. How would you like to proceed with your case? Would you like to accept this plea offer, or would you like to plead not guilty and have a trial in your case, as you are entitled to do so?
I plead no contest.
I'm going to ask you again. The state has made an offer. Do you understand the terms of the offer that the state has offered, that's presented to you?
Can I hear the offer?
All right, Ms. Daciano?
Yes, Your Honor. The offer is 12 months probation, served 24 days, credit for time served 12 days. That's from October 26th to October 31st of 2023. Balance suspended, a stay away from 484 Peachtree Street, Atlanta, which is the Medical Arts Building.
All right. That's the offer, Mr. Long. What would you like to do?
I would like to plead no contest.
I'm not going to grant you a no contest plea. It's either a guilty plea or a not guilty, and we'll schedule your case for trial. What would you like to do?
Not guilty.
All right. So, Mr. Long, you've been accused of criminal trespass. Would you like me to read the accusation, or do you want to skip the reading of the accusation?
Read it.
Okay. This accusation was filed on October 27th, 2023, with regards to Mr. Andrew Todd Long. And the accusation in this particular case states that Keith Gamage, Solicitor General for the County of Fulton, Georgia, on behalf of the citizens of Georgia, do hereby charge and accuse Andrew Todd Long of the offense of criminal trespass and misdemeanor for that said accused in Fulton County, Georgia, on or about October 26, 2023, did knowingly and without authority enter upon the premises at 484 Peachtree Street after receiving prior to such entry notice that such entry is forbidden by the owner and that the authorized representative of the owner, in violation of Georgia law, OCGA section 16-7-21. Upon this accusation, a bond was set in which Mr. Andrew Long was granted a $2,000 signature bond through the jail on October 30th, 2023. Thereafter, Mr. Long failed to appear in court on December 6, 2023, and a bench warrant was issued. Therein, Mr. Long is now in custody for failure to appear in court. All right. Mr. Long, if you decide to plead not guilty to this charge, the case will be scheduled for trial. At the time of the trial, the prosecutor would have the complete responsibility and burden to prove the charge against you beyond a reasonable doubt. If the prosecutor does prevail and overcome your legal presumption of innocence, you will be convicted and face a penalty of up to a year in jail and or up to $1,000 fine. Given this information, how do you plead?
What? Not guilty.
Understood. Your case is now arraigned. We've recorded your not guilty plea, and it's going to be further notice for trial. You'll get notice of when to come back to court for trial. Thank you.
Probation number 3 and 4, Peterson.
Good morning.
Good morning, sir. Mr. Larry Peterson is convicted of theft by shoplifting in case 21 CR 004038F from April 13th, the incident date was April 13th, 2020. His probation revocation matter is 24 PV 712. Mr. Peterson, you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Vigiletti. Ms. Vigiletti, are we ready to proceed?
No, if it's possible to speak with Mr. Peterson briefly, we had some difficulty tracking him down yesterday. Seemed like maybe there's some activity on 4 North.
Well, we can go to position number 6 through 11. We can do him later.
Okay.
All right.
Mr. Grant Bolden.
Is he on the SAP calendar?
Yes.
All right, thank you.
This is positions 6 through 11, Your Honor.
All right. This is State versus Christopher Grant Bolden. Mr. Bolden has 1, 2, 3 cases and 1, 2, 3 bench warrants. Let me just go through the bench warrants first, and they are 24 FTA 483, 484, and 485 for failure to appear in court on February 27, 2023. His underlying cases are 20 CR 217B, accused of simple battery family violence and battery family violence from November 6, 2019. His second case is 20 CR 1397B, accused of battery family violence from February 12, 2020. His third case is 22 CR 7734B, accused of theft by taking from November 6, 2022. Mr. Grant Bolden, these are the 3 open misdemeanor cases against you, in addition to the 3 bench warrants. You have a right to remain silent. Anything you say in open court, the statements can and will be used against you. You have a right to an attorney, and Mr. Michael McLean is representing you. Mr. McLean, how will we be proceeding, please?
Your Honor, I think this is going to be in the form of a non-negotiated plea. I've talked to the state about a counteroffer, but I think the state can't bend my way, so I'll ask to persuade the court.
All right. Mr. Grant Bolden, we are going to have a non-negotiated plea hearing, which means that the prosecutor is going to give its offer and substantiate the offer with an argument, including your criminal record history and perhaps also the reasons for the offer based upon the allegations of the charges. Your attorney is then going to give me an alternative argument. I will consider both sides and I'll give you my decision as to which option I will select. Please keep in mind that if you're not happy with the court selection, then you have the right to plead not guilty and have the cases further noticed for trial. Ms. Falk, what is the offer for Mr. Grant Bolden?
Yes, Your Honor. So this is a global offer. So it is kind of all cases are part and parcel with one another. The global offer on this case is on position 6, 12 months concurrent with count 2, Count 2, 12 months served 98 days, credit for time served 16 days. That's going to be from January 1 to January 3 of 2020, November 11th to November 14th of 2022, and April 24th of 2024 to today. Balance probated, stay away from 955 DeSoto Street Northwest. No further contact with Ashley Marie Still, Family Violence Intervention Program, 60 hours of community service. Position 7, a family violence battery. These are against the same victim. 12 months served 90 days, credit for time served 12 days. That's going to be from February 12th, 2020 to February 14th of 2020 and April 24th, 2024 to today. Balance probated, stay away from 955 DeSoto Street Northwest. No further contact with Ashley Marie Still. No firearms. That's going to be concurrent with the previous case. And then on the next case, it's a theft by taking. That is 12 months probation, served 92 days, credit for time served 13 days. balance probated in anti-theft course, stay away from 439 Edgewood Avenue, which is the municipal market, a $200 restitution to the municipal market. We are additionally, just to kind of put the facts on the record for this case.
Before you proceed with that, is the
Yep.
theft by taking offer concurrent or consecutive to the second case?
It didn't say, Your Honor, but everything is concurrent unless otherwise specified.
Okay.
Well, it's a non-negotiated plea, so we're asking that it run consecutive. So the recommendation is based on a number of factors, kind of going through the history here. This defendant has a total of 12 cycles. The 12 cycles include a driving without a valid license, a theft by taking in 2011 in Henry County State Court. The defendant received first offender for that, and it was in conjunction with a burglary as well. That was sealed. We also have a probation violation from, 2012 in, just looking at the date on this one, where he was found guilty and given confinement. Driving without a valid license, 2013, found guilty. Probation violation, 2014, found guilty. 2020, we have one of our cases, both of the family violence cases. 2022 is a failure to appear arrest. 2022 is this theft by taking, and then a failure to appear in 2024, which he was arrested on all of these failure to appears. The facts of all of these cases, Your Honor, on the first case, it is that in November of 2019, officers got a call to DeSoto Street. They spoke with Miss Ashley Marie Stills. She stated the defendant had come to pick her. They went out drinking with the coworkers and the defendant picked her up. There was a miscommunication and she was dropped off, and where she and the defendant lived together. She stated that as she entered the door of the residence, he called her a liar about where she was and started punching her in the head multiple times. Officers did observe swelling and abrasions to her forehead. The next case that occurred was in February 12th of 2020, about 3 months after the first case. They arrived at DeSoto Street again, the officers did, and spoke with Miss Stills. She stated she came home, saw a broken mirror. They began arguing about the broken mirror. He denied breaking it. She then said, oh, so we're breaking stuff, and then broke a TV in the home that belonged to her. At that point, he became upset. Ms. Still advised that the defendant became upset, attempted to break another TV in the home. He then pushed and kicked her. He began pushing and kicking her again on the bed. She said that at that point, he threw a charger block at her, striking her in the face, causing a small welt on her face. And she also stated at some point he began dragging her, which caused visible scrapes to her knees. Officers did observe the scraping to her knees and the injury to her face. And that was the basis for the second family violence battery. The next incident, the theft by taking, involved the defendant who the officer spoke to Miss Bailey Flattery, who stated that she was advised by her accountant that the seal was broken on a plastic deposit bag, which contained $529. $200 had been stolen from that bag. They watched a surveillance video and observed the defendant, who was an employee at the store, gathering the deposit bag from a coworker, and then ripping open the seal and looking in both directions, stooping down near the counter, and then walking away from the area with the money in his hand. And so that is the basis of the theft by taking in this case. The state's recommendation, I believe, given the fact we were dealing with 2 family violence batteries and a theft by taking, is more than fair. We have had an opportunity to, let me just double check this for a second. We would ask that the defense, if they do take the plea, stipulate to venue, factual basis, and identification. We would like to sound for Miss Ashley Still, and that is all for the state.
We do stipulate to.
Well, let's see what, before you enter into any stipulations, Mr. McLean, what modifications are y'all seeking?
Your Honor, his situation is this. Let me give a little background first in the same time frame that we're talking about for the facts of the case. One case was 4.5 years ago on November the 6th of 2019. And that's the family battery violence, battery family violence and simple battery family violence that occurred. Then a few months later in February, just about 3 months later, 4.25 years ago, was the other battery family violence. So there, I would simply like to emphasize the length of time that's been since those cases. Now, oftentimes it's said that an FTA caused the person himself to be at fault for the cases being so old. But I would note that the cases, all 3 FTAs are because apparently all 3 cases were on a calendar on February 27th of 2023, and that's the date he missed. When he's homeless, he doesn't get his court notices apparently, so that's the reason for the court date being missed in February 2023. Homelessness also causes stress, and that's why he was dishonest and stole the $200 of the $529 that was in that plastic bag. He took out $200 of it and causing the deposit to be quite short. And that was on November the 6th of 2022, coincidentally 3 years to the date after the case. So I would just emphasize to the court that the family battery violence, all the domestic violence is over with. He's 31 years old now. He's more mature. He was dishonest again on, however, stealing the money a 1.5 years ago. And he is remorseful about all these cases. That mention of the burglary, when he was 18 years old, he lived in the neighborhood, and a neighbor of his deceased. And about 1 year after she had died, her home was still empty, and he squatted. He moved in for about a week and was sleeping in the house, which was empty for 1 year. And the relatives were checking on that house every week or so in preparation for moving things out. And they noticed that he was there. He was arrested, charged with burglary, and pled guilty to it apparently. And that was in another, and he was 18 years old. So I did hear the other things that were mentioned by the state. Now his bond situation, he can't make his bond. Right now it's $2,000 on one, $1,000 and $1,000 for a total of $4,000 bond. If he had about $500 to a bonding company, he'd be out. But he's got a new job at Hot Dottie. It's not Hot Daddy, but it's Hot Dottie. It's a restaurant in Dunwoody, Georgia. And the boss told him, his supervisor told him, when he went to jail on this, I'll hold the job open for you for a couple of weeks. If he does 33 days extra starting today, he's probably lost that job. So I would ask the court to consider overall that if the court could cut that down to something like 1 or 1.5 weeks more. He's already been in 16 days, just 2 weeks.
I've got him in for 9 days.
I'm sorry?
He's been in custody for 9 days.
9 days? I thought we had the
He was booked in on April 24th, 2024. So was he somewhere else before this?
Oh, no, Your Honor. The 16 days credit on the first case, that includes some days that he spent.
Oh, I see what you mean. Okay.
That is correct.
Right. So with 9 days in now, and the boss and the supervisor telling him, gee, I'll hold your job for you for 2 or 3 weeks. He's simply hoping that the court could calculate a way for him to get out and keep that job. That's his only point. He is taking responsibility for everything and wanting to clear up everything and start fresh.
Your Honor, if I may make 2 points before you make your ruling.
Yes.
Just one in response to what P.D. McLean said about the failure to appear. On 20 CR 00217B, the February 27th, 2023 failure to appear was actually not his first failure to appear. His first failure to appear was September 7th, 2021 at the arraignment for Judge Porter. Looking at his case on my case management notes, he failed to appear on that date. It was a 1:30 p.m. arraignment. He failed to appear in 2021. The case was then put back on a calendar, February 27th, 2023, where he failed to appear again. And at that point, a bond forfeiture judgment was issued against him July 14th of 2023. So the state bears no responsibility whatsoever for the fact that the defendant couldn't make two different court dates on a case. And nor do we bear responsibility for the reason the case is so old. It is only by the actions of the defendant that we are now 3 years later addressing this case instead of addressing it back in 2021 when it was on the calendar the first time. Additionally, I would like to modify the recommendation, the portion of the recommendation on position 8, instead of jail time to be 12 months probation consecutive to count 1, balance probated, so it would make for a total of 24 months. Since we are asking for family violence intervention, restitution payments, anti-theft courses, and community service, that should give him ample time to complete those items. That's all for the state.
All right. Anything else, Mr. McLean?
No, Your Honor.
All right.
That's it.
I'm going to modify the sentence time. It would be to serve, what is it? 36 days. Credit for time served 18 as well. The 9 days that he's been in custody. So I guess I'm going to modify it to 36 days. So he would be done with jail time on position 6. He would be done with, he will not be quite done with jail time on position 7. And then the theft by taking would be a consecutive probation. All other requirements are in place, which means Mr. McLean, you're much better at this calculation. For position 7, he would have, would you say, another 6 more days to serve at the jail?
Yes, Your Honor. That would work.
But here's the stickler. For the first 6 months of probation, he will be reporting twice a month. I'm glad that he's employed and I hope he has a regular residence, but at least for the next 6 months, he will be working in order to pay off his debts to society.
Yes.
And if he violates any condition of his probation's authorized to issue a warrant so that he can serve up the rest of the 2 years in jail. Mr. Grant Bolden, if you decide to accept this plea offer, you will be on probation for up to 2 years. For the first 6 months, you'll be required to report twice a month. You'll be required to do your domestic violence intervention program, your anti-theft class, your community service, no contact with the individuals, and restitution to the municipal market. So if you believe that this is not a workable plan, then you are free to enter a not guilty plea and we can reschedule this case for trial. What would you like to do?
Your Honor, I really couldn't hear everything that you were saying as far as the jail time and what.
If you decide to accept this offer, you have to be in jail for an additional 6 days.
Okay.
After that, you report to probation. You report to probation twice a month for the first 6 months. You'll be on probation for up to 2 years. Did you hear that part?
Yes, Your Honor.
If you violate any of the conditions, if you don't report to probation or you don't complete your programs, you will be arrested and brought back to jail to serve the rest of the 2 years in prison.
Yes, Your Honor. That's approvable. Yes, Your Honor.
Okay. Ms. Thomas, Ms. has indicated if you could read the chat, Mr. McLean, they would need their contact information. All right. So with that, Mr. McLean, do you stipulate to the factual basis, venue, and ID for these 3 open cases against
We
Mr.
do.
Grant Bolden?
We do.
Right? Sorry, Mrs. Thomas is submitting, if you're representing, okay, if you're accepting probation that has restitution, they have to pay, could you please email the victim contact information? All right, that would be for Miss Falk.
Yes.
All right, okay. Mr. Grant Bolden, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Have you consumed any medicine or alcohol?
Have I consumed any
Have you,
medicine or alcohol?
have you consumed any medicine or alcohol recently?
Not since I've been in here, and as far as alcohol, no.
Have you understood what's been going on in your case? You can put your hand down.
Yes, ma'am. Yes, Your
Have
Honor.
you understood, and are you satisfied with your counsel?
Yes, Your Honor.
Is anybody forcing you or inducing you to take this plea today?
No, Your Honor.
Are you doing so freely, willingly, and knowingly?
Yes, Your Honor.
If you decide to plead guilty to these 1, 2, 3, 4 open charges, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get the opportunity to go back to court with your lawyer, to confront your accuser, challenge the evidence brought before you, present your own defenses, arguments, and mitigating factors, and have the state carry its burden and prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
Being convicted of 2 counts of battery family violence will go on your permanent record. If you are ever arrested again for a same or similar offense, it will be a felony charge. Has that been explained to you?
Yes, Your Honor.
Are you still prepared to move forward with this plea?
Yes, Your Honor.
In case 20 CR 00217B, how do you plead to simple battery family violence and battery family violence?
Guilty.
On the simple battery, it'll be 12 months probation concurrent with count 1, battery family violence. That on count 2 is 12 months to serve 36 days, credit for time served 16 days. The remainder of the time will be on probation. You will report to probation at 132 Mitchell Street on the first business day after you're released from the jail. When you report to probation, you must report before 3 p.m. The other conditions are that you're to stay away from 955 DeSoto Street, Northwest Atlanta. You're to have no contact with Ashley Ashley Marie Still. You are to begin a domestic violence intervention program and complete 60 hours of voluntary community service. You are to enroll in the domestic violence program within 60 days of being released from jail, and you're to begin your 60 hours of community service, beginning with 5 hours in the first month and completing a minimum of 5 hours every month thereafter. Do you understand?
Yes, Your Honor.
In the second case, how do you plead to battery family violence in case 20 CR 1397B?
Guilty.
Your sentence is 12 months to serve 90 days, to serve 36 days, credit for time served 12 days. For that case, you have an additional 6 days to serve at the jail. Once you're completed with those 6 days, you will report to probation, and this will be concurrent to position 6. While on probation, you will also stay away from the DeSoto Street, have no contact with Ashley Still. You're not to be in possession of any firearms. You're not allowed to own or possess any firearms. And then you're also required to do that domestic violence program and 60 hours, which is concurrent to position 6. With regards to your third case, 22 CR 7734B, theft by taking, how do you plead?
Guilty, Your Honor.
This will be 12 months probation consecutive to position 6. And which means that these 12 months of probation will tack on after you finish the first 12 months. Do you understand?
Yes, Your Honor.
So you're on probation for up to 2 years.
Yes, Your Honor.
You'll be required to do an anti-theft class, and you must complete that theft class within the first 3 months of reporting to probation. You have to stay away from the municipal market at all times, which is at 439 Edgewood Avenue in Southeast Atlanta. And you have to pay a $200 restitution to the municipal market. You will begin paying your restitution after the first 6 months of reporting to probation, where you'll need to make a minimum payment of $25 from the 7th month and thereafter. Understood?
Yes, Your Honor. Yes, Your Honor.
Mr. Grant Bolden, I need not, I'll be very frank, for the next 2 years, you will be working to pay off these debts to society. If you get arrested again for anything else, probation is authorized to revoke your probation and have you serve out the rest of the time in jail as well.
Yes, Your Honor, I understand.
All right, don't give us a reason to do so. Positions 9, 10, and 11 are null prost.
Yes, Your Honor, and the state will prepare those null process. I do have to step away for an hour. I will be back for the competency calendar at 11 o'clock. In the meantime, supervising ASG Anna Allen will be sitting in my stead until I return. Thank you.
All right, Ms. Falk, thank you. Welcome, Ms. Allen. And let's begin with our next case.
Next is position number 22, Williams.
I'm sorry, Deputy, your voice broke up at the last part. Something Williams?
That would be Darian Williams.
Position number,
That's 22, Darian Williams.
Okay. All right, the audio at Jail Court iPhone is not very clear. So Mr. Darian Williams, if you can't hear us, please raise your hand, okay? No. Put your hand down. Put your hand down. Okay. Can you hear me now, Mr. Williams?
Yes, ma'am.
All right. If there are times when you cannot hear us, you must raise your hand. Okay. This is State versus Darian Williams, 24 CR 1844G. Mr. Williams is accused of battery, family violence, and criminal trespass from April 11th, 2024. His second case, no, I think that was his only case, wasn't it?
That's it.
Yes, Judge.
Okay. Mr. Williams, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. McLean. Mr. McLean, how are we proceeding, please?
Your Honor, I had a discussion with the state about the possible counteroffer that was not accepted. I believe his default position from our conversations this week and last week is that he will accept the negotiated plea as it is.
So he's willing to accept the negotiate. So this is going to be a negotiated plea, correct?
Correct.
Sometimes I do apologize, Mr. McLean, but sometimes I just need to summarize what you just asked. So.
Okay.
All right. Ms. Daciano, what is the offer for Mr. Williams? And I'm listening. I'm going to go to my printer to get something. Thank you.
Yes, Your Honor. For count 1, it's 12 months probation, serve 60 days, credit for time served 15 days. That will be from April 11th of this year until today. Balance probated, FVIP, 40 hours community service, no further violent contact with Shaquila Williams, a stay away from 2389 Connolly Drive, and no firearms. And then for count 2, it would be 12 months probation concurrent with count 1. At this time, I'd ask the defense to stipulate to venue, factual basis, and ID for purposes of the plea. And if the court could please sound for Ms. Shaquila Williams.
Right. Ms. Shaquila Williams, if you'd like to contribute, this will be the time to start your video and audio. And Mr. McLean, do you so stipulate?
We do.
All right. Mr. Did somebody say something? All right.
Yes, Your Honor.
Are you Ms. Williams?
This is Shaquila Williams' mother.
Okay.
I'm here
Just give
for
me,
her.
just give me a moment. Just give me a moment.
Okay, okay.
Miss, would the host please prompt iPhone to start their video? Miss Williams, look at your screen. You need to start your video. Okay.
Okay.
Please raise your right hand. And Darian Williams, also please raise your right hand. Other right hand. Thank you. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
All right. Mr. Williams?
Yes, ma'am.
All right. Yes, ma'am. And may I ask what's your name?
My name is Stephanie Collins. I'm Shakila Williams' mother. She had me to be here today. She had a important appointment this morning.
What would you like to tell us?
With
If you could please not walk around, just sit down.
okay.
Thank you.
Okay, I will. My grandkids are here and they're moving around, so that's why I was moving around. They were saying stay away from. He lives with his mom. His mother don't have a problem with him coming home. She's concerned about him as well.
Okay.
And she
Honor.
was wondering,
Just 1 second. Just 1 second, ma'am.
Okay.
Ms. Desiano, just to confirm, is no further violent contact, correct?
That's correct, Judge, but we did speak to Miss Williams yesterday, and I will say we read the plea offer to her and she was in agreement with it at that time. So to hear that she wants it changed is a surprise to me.
All right.
Yes, she spoke.
What do you
with me.
want to change?
His living arrangement.
I don't
And
know.
another,
I
and
don't
she
know
said
what
she-
his, I don't know what his living arrangements are. All he's required to do is to have no violence with Shakila Williams and to stay away from 2389 Connolly Drive. So
That's it right there.
what? The staying at
The address, yes, from the 2839 Connolly Drive.
All right. So, but Miss Williams has already indicated that that's what she wants.
I spoke with her.
She would need to be here to confirm otherwise.
Well, they can call her.
All right, I'll have the prosecutor call her.
Yes, because he don't have another living arrangement. I live out of state, so he can't come live with me because I live out of state. I don't know if the prosecutors or what have you even.
What is your relationship with Mr. Williams?
I'm Shakila's mother. I'm his grandmother.
Okay, so Miss I'm sorry, it was Colburn, wasn't it? Stephanie
Collins.
Collins. All right, Miss Collins. If you don't want him to live with you, I think he got the message right now.
No, I didn't say I didn't want him to live with me. If he can go to another state and how he's going to report.
That's his problem, Miss Collins.
I don't think there was any talk about him going to another state, though.
No.
No.
Miss Collins, all I can say is that right now he cannot stay at the Connolly Drive. If Miss Williams wants him to stay at the Connolly Drive, she needs to be on Zoom. So if you want to reach out to her and let her know, that would be imperative.
Okay, I would do that now.
Thank you. Thank you.
As far as I know, not being on Connolly Drive is acceptable to Mr. Williams.
Oh, okay. So that's a non-issue at the present time. The host can go ahead and mute iPhone, please. All right. Going back to Darian Williams. Mr. Williams, can you hear me all right?
Yes, sir.
Okay.
Yes.
And Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do, Your Honor, for the purpose
All right.
of the plea.
Mr. Williams, have you consumed any medicine or alcohol recently? You need to say yes or no.
No, ma'am.
Okay. And have
No,
you understood
ma'am.
what's going on so far?
You said what?
Have you understood what's going on in your case?
Yes, ma'am.
All right. And are you satisfied with your lawyer?
Yes, ma'am.
If you decide to enter into this guilty plea, you will have a battery family violence conviction on your criminal history record. Are you prepared to accept that?
Yes, ma'am.
You understand that having such a conviction can result in a felony arrest if you ever get arrested for the same offense.
Yes, ma'am.
All right. Are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
You would have to give up your constitutional right to a trial if you decide to plead guilty. You will not get the chance to confront your accuser, challenge the evidence brought before you, have the state carry its burden to prove the charges against you beyond a reasonable doubt, and present your own defenses or arguments. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of battery family violence and 1 count of criminal trespass?
Guilty.
Your sentence on the battery family violence is going to be 12 months to serve 60 days, credit for time served 15 days. You have an additional 15 days to serve at the Fulton County Jail. Did you understand that?
Yes, ma'am.
All right. After you have served out the additional 15 days, you will report to the Fulton County Probation at the first business day. The probation office is located at 132 Mitchell Street, and you must report before 3 p.m. While on probation, you will complete a domestic violence intervention program, and you must begin those classes within 30 days of being released. So by your second probation visit, you must show proof of enrollment with those classes. Do you understand?
Yes, ma'am.
You're also to complete 40 hours of community service, and you must begin your community service with completing at least 5 hours in the first 30 days, and then do a minimum of 5 hours every month. You will report to probation every month. You shall have no violent contact with Shakita Williams, which means that you can meet your mom and you can have conversations with her, but there cannot be any physical and verbal altercations. You're also to stay away from 2389 Connolly Drive. I guess that's your mother's home. You have to find somewhere else to live.
Okay.
Within 30 days of being released, you must update your probation officer with your address. Do you understand?
Yes, ma'am.
You are also not to be in possession of any firearms. You cannot own or possess or be near any firearms. On the criminal trespass, your sentence is 12 months concurrent with count 1. That concludes your plea. Thank you.
Oh, can I add, Your Honor? Mr. Williams?
Yes.
He's gone. That's okay. I'll talk to him later.
All right, Mr. Mullins, you're free to go.
Okay, next we have on a probation calendar, positions 3 and 4, Mr. Peterson.
All right.
If I could please speak with Mr. Peterson, Judge.
Have you spoken to him?
No, I have not. They have been using the iPhone for other clients.
All right. Did they send you the number for the iPhone?
They were using it.
No. Do you have the number to the iPhone in question?
Oh, I don't. I assumed we would be in a breakout room since we're alone here, but
Okay, no, okay, that was the other option. I can do that. Let me see,
thank you
is
so much.
any other location ready to present a case at the jail facility? ACDC or any other location?
I believe everyone else will probably come through the jail court iPhone this morning.
Okay. In the meantime, jail court iPhone and courtroom 2 will put you in a breakout.
Okay.
And jail court iPhone, I think there is some Wi-Fi connections. It's not very stable. The audio is coming in and out. So I don't know if you want to try leaving the Zoom after the breakout session and then coming back in. Okay.
Okay, it's probably the area we're in up here.
Okay, but right now we're going to put you in a breakout.
So Judge, who's going in the breakout?
Jail court iPhone and courtroom 2.
Thank you.
We'll be in a brief recess until someone pops in to do the next of the calendar. Thank you. Oh, Miss Vigiletti, you'll have to, is she in the breakout? Oh, good. Thank you. All right, Miss Grace, if you could please tell the breakout room that we are ready to address the case, please. Thank you. And they need to come back into the main session. Okay, is courtroom 2 back from the breakout? Okay, great. Ms. Vigiletti, how are we proceeding?
This is a probation case, Your Honor.
And okay, let's begin with Mr. Larry Peterson. Case 21 CR 4038F, in which he was convicted of theft by shoplifting, and his probation violation matter is 24 PV 712. Mr. Peterson, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you, and your attorney is Ms. Vigiletti. Ms. Allen, when was he convicted and what's probation seeking?
Your Honor, he was sentenced to probation for the theft by shoplifting on June 27th, 2023. He was required to complete a shoplifting course and report to probation. Your Honor, he's been in custody since April 24th, 2024. He has 181 days remaining on his case. He currently has a new charge of burglary and theft by taking. At this time, probation recommends that his balance be revoked.
All right.
And I know Ms. Vigiletti had sent me an email earlier this morning concerning his credit for his time served and once he was sentenced to probation, but our records show that he was only given credit for 23 days originally when he first was sentenced to probation.
All right. And all right, I'll let Ms. Vigiletti add to that. Ms. Vigiletti?
Yes, Judge, the question of time served might be a bit of a policy question because his plea statement and the probation paperwork does say probated after 46 days, credit for time served 23 days. So I believe Ms. Allen is calculating the 23 actual days he served, and I'm calculating the 46 days, given that the jail gives double credit.
Okay.
He has also been in custody.
So
now.
how many days do you believe that he should be given credit for today?
So if we give him credit for the full 46, as well as the 9 that he's been in this past week and a half, I believe he has served 216 days.
I'm sorry, he was required to report to probation. So how would he have served 216 days?
No, I'm sorry. I need credit for 260 days. So 46 days credit for the jail time, then 161 days before the probation was violated, and then he's just been in for 9 additional days.
No, that's not how I'm going to calculate it. He's got 181 days left on probation.
Okay, so just so I understand, as a matter of policy, when the
It's a matter of policy when they're incarcerated at the Fulton County Rice Street Jail under the auspices of the sheriff of Fulton County. But
Sure.
once they are outside, that does not apply.
Okay, so, okay, understood. So the language says probated after 46 days. It really should say probated after 23 days.
It should.
Okay. Okay, understood.
All right. The point is still that he has failed to comply with probation while he was on a release status, serving a sentence, and he has not completed the conditions of his sentence. So they are asking me to revoke 181 days. What is the defendant's position?
Yes, Judge, we're asking today for Mr. Peterson to be allowed to continue on probation. He does have a good long time left, 6 months left on his probation. He tells me he did start, the only requirement for probation, aside from reporting, was taking a shoplifting course. He told me he did start the course. He got quite sick and became homeless. He's unemployed. He became homeless. He actually got arrested in December and has been in custody ever since. So he's had a very
That's for his felony charge then.
That's for a separate charge in Peach County.
I see.
And has been in custody ever since. So I spoke with Mr. Peterson, really wants to get back on his feet. My intention is to send a social worker to help him sort out his homelessness and employment issues so that he can have enough stability. As I said, there are 6 months left on this probation, so if he can get his feet under him, I'm confident he can get that shoplifting course done in that amount of time.
Okay. Miss Tyson, do you have a history on Mr. Peterson in terms of FTAs and probation violations?
Here's an FTA from June 5th of 2023 in Fulton County. There's another FTA, September 28th of 2022 from Fulton County. And you said probation violations, correct?
Yes.
Here's a most recent probation violation is from 2013, Your Honor.
Okay.
And then 2012 before that.
Right. I am going to partially grant the state's request. This is going to be recorded as a probation violation for this case. He is going to have to serve 30 days, given credit for 9 days. That means he has 6 more days to serve in the Fulton County Jail for this probation violation. Once he's released from his felony hold, he will report to probation the very next business day before 3 p.m. He will report twice a month and he'll be required to complete the anti-theft class. As soon as he completes the anti-theft class, his probation will be non-reporting.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Good luck, sir.
Parallel logic, let's see what she does.
Jail court iPhone, anyone else? Or maybe we're holding. While we are waiting, I'm just going to go over the calendar with the attorneys on Zoom. On the probation violation calendar, the only other case we are waiting on is Ronnie Smith. And who's representing him? Mr. McLean, have you had a chance to speak with him?
Yes, Your Honor.
Okay, just I'm gonna be sure. Thank you. On the add-on calendar, our pro se defendant. That is Mr. Long, and he has entered a not guilty plea, and the case has been arraigned and further notice for trial. On the regular calendar, position 1, DeMarcus Anderson, what would you like to do, Ms. Vigiletti?
Oh, yes, Ms. Allen, DeMarcus Anderson, this charge is from 2015, and I only have the accusation. I've scoured Odyssey, and I think probably because of the age, I have nothing else, and Mr. Anderson has no memory of it. So, he's here on other charges, a week reset to give us a chance to try to get some sort of documents to refresh his memory.
I'll look right now and let you know.
Thank you so much.
Yep.
Position 2 and 3, Ronald Anderson. What are we seeking a reset and for what purpose?
Yes, Judge. Mr. Anderson, would like to enter a non-negotiated plea, but in part based on, his job, and he would like his employer to be present, and I left his employer a message and just haven't heard back. And so, he said if he needs a couple more days to make a good case for him, that he's willing. So if it's possible to get him on the calendar next week, so that we can discuss a plea, that would be fantastic.
We're going to reset it to May 9th at 9 a.m. for a plea. And for, I guess, his boss to appear.
Thank you.
All right. Position 4, Tariq Barnes. Mr. McLean, I wasn't sure how you're proceeding.
The state had made an announcement. He was on previous calendars, but he had a felony probation matter or something like that that caused him to say, could I have a reset so I could talk with my felony lawyer? I don't know if he's talked with his felony lawyer yet. In the meantime, the state has been looking at it further and made a comment on this week's calendar that they were thinking of transferring it and had emailed the DA. I guess it's more than just thinking about it. They, I guess, requested that it be transferred as felony, but I don't know if they've heard back.
Miss Allen, any status on the request?
I did just review the multiple arrests in February for this gentleman. He currently has bonds on both of the cases. These are related to the same victim, one out of Palmetto, I believe, Police Department. So he is currently in jail on charges from the 4th of February, 2024, which is this case. That's also a pre-filed DA case, and there is an existing bond already. We have requested a transfer, and I see the documentation in our system. And it's based on the fact that this battery in our instant case, 24 CR 0000793A, is actually a felony because of a prior.
All right. I'm going to do a final reset to May 9th. And if the state needs to let us know whether they want to make an offer or whether they are getting the case transferred, or Mr. McLean, whether your client wants to have the case arraigned, but he'll need to be brought over for one of these 3, door 1, door 2, or door 3.
All right.
Thank you.
Position 5, 6, and 7, and 8, and 9. No, sorry, 8, excuse me. Position 5 through 8. Those were all pleas. 9, 10, and 11. Those bench warrants were null crossed. Position 12, Ibrahim Harris. Mr. McLean?
We've never met him. The deputies, oh, you've met him once?
Judge, this is the case where Mr. Harris, I withdrew from the case last week because of his behavior towards me.
Correct. Have we had another PD speak with him?
Mr. McLean tried and he won't meet with him.
Okay. All right. Hopefully he'll be brought over this morning. Thank you. Lawana Tamisha Johnson, position 13 and 14. She has been released and the case is further noticed for trial.
Oh, Your Honor, we just got a call. Could the host let the jail iPhone into Zoom?
Repeat, Mr. McLean. You want to go into a breakout?
No, the deputy just called and asked if the jail iPhone could be let in.
It's let in. It's on Zoom.
All right.
All right. Jail court iPhone. Who do we have, please?
On a probation calendar, we have positions 5 and 6.
All right. Thank you. This is State versus Ronnie Smith, case number 22 CR 75208, in which Mr. Smith was convicted of one or more of the following charges: criminal trespass, stalking, and reckless conduct. Position 6 is the probation violation matter 24 PV 000573. Mr. Smith, you have a right to remain silent about the facts of your case. Anything you choose to say can and will be used against you. You have a right to an attorney, and Mr. Michael McLean is representing you. This is a probation revocation matter. So Ms. Allen from the Fulton County Probation Office is already been sworn and going to testify as to when you were convicted, what were your requirements, and why they're seeking a revocation. Ms. Allen?
Your Honor, the defendant was sentenced to probation on August the 16th, 2023, where he was charged with the offense of criminal trespass, stalking, and reckless conduct. He was required not to have any further contact with the victim, Rachel Thompson, and complete 40 community service hours. The defendant never reported to our office. He failed to provide documentation of completing the 40 community service hours. It's 120 days remaining on his case, but Your Honor, he has been in custody since April 3rd, 2024.
On this probation warrant?
Yes, Your Honor.
Okay.
Your Honor, also, this case was actually reset from the calendar, the April the 25th calendar, because he did receive new charges, the offense of battery, family violence, as well as criminal trespass.
Yes, I do see that. New charges from November 26, 2023.
And yes, Your Honor, and it looks like October the 2nd, 2023 as well for the criminal trespass.
All right.
Your Honor, at this time, we ask that his balance be revoked.
Okay. And he's been in custody for 30 days.
Yes, Your Honor, he's been in custody since he was booked April the 3rd.
Okay. Mr. McLean?
Your Honor, we believe that the correct calculation on the 120 days is actually 90 days. And the issue basically is he has denied the new charges. He says they are not true. Cloaked with the, is cloaked the right term really, with the presumption of innocence, Your Honor, what we're looking at is what is a fair revocation for the failure to report and the failure to do the 40 hours. So as a failure to complete conditions revocation as opposed to a new crime revocation, what would be the fair amount? He's been in for a while. He does have a job he would like to get back to, and he does say that he didn't do the new things. So if the court could consider either time served, close to time served, or a continuation of probation so that he could do those 40 hours or whatever it was, that would be preferable to him. And that's what he's requesting the board to do.
Okay. So he's required to do 40 hours of community service and to stay away from Rachel Thompson. And what I've understood is never reported, and he's never completed his 40 hours community service. This is going to be recorded as a probation violation. He's going to be serving 30 days, and the court will not give him a 2-for-1 opportunity. The court will deem his 30 days to be satisfactory for the probation violation. So which means it leaves him with 90 days left on probation. Has he made bond on the new charges?
No, Your Honor, he has not yet made bond on the new charges. He hopes to. Now, Your Honor, we do believe that the 120 total should be calculated at 90.
Denied. It's denied. This is a probation revocation matter. I'm not considering that for purposes of probation revocation.
Well, Your Honor, it has to do with how many days he was in, I believe, prior to his conviction.
As I've said, Mr. McLean, I'm not considering any time prior to the conviction. That's already been part of the disposition. I'm only considering time that I can attribute to the revocation. All right, so that is the sentence of the court. Once he is released on his other outstanding charges, he will report to probation immediately.
Sure.
And he will report twice a month. And he'll be required to do his 40 hours of community service, and that must begin with a minimum of 10 hours per month. And once he has completed his 40 hours of community service, his probation will be non-reporting.
Okay.
Your Honor, my apologies. I must have missed the first part of it.
Okay, this is going to be recorded as a probation violation. He's to serve 30 days. The 30 days that he has been in custody so far, that is going to be attributed to this probation violation. So which means that he has 90 more days left on probation. I am not giving him a 2-for-1 benefit. So that means he has 90 days left on probation. Once he bonds out on his current outstanding charges, his probation will then re-begin again, and he'll need to report to probation and complete the 40 hours of community service with a minimum of 10 hours per month.
We do.
Once he
understand,
completes the community service, his probation will be non-reporting.
Sorry for my confusion earlier, Your Honor. Yes, we do understand the sentence, and that is very good. Thank you.
All right.
All right. Your Honor, that concludes my business. May I be excused?
Yes, Ms. Allen. Thank you.
Thank you.
All right. Mr. Smith, this is a probation violation for your criminal trespass, stalking, and reckless conduct conviction. So your time has been served already for the probation violation. Once you're released from jail, you must report to probation. If you don't, you'll be back in jail again.
Yes, ma'am.
So if you are released on a Monday, you have to report to probation on Tuesday before 3 p.m. And you will report twice a month.
Yes, ma'am.
And you need to complete your 40 hours of community service. Once you're done with your community service, then your probation will be non-reporting.
Yes,
But
ma'am.
if it's not completed, you better be best friends with your probation officer.
Yes, ma'am. Can I ask you one question before we get off? You said
Go
I
ahead.
completed.
Go ahead.
For my probation on time served with the completion.
Your probation will be non-reporting once you have completed your community service.
30 days, like you said, the 30 days being completed. I'm just trying to
You
add.
already completed your probation violation. You still have 90 days left to serve on probation.
Man, that's all I need to know. Yes, ma'am. Thank you.
Okay.
All right.
Thank you. You're free to go. Jail court item. Next case.
We have positions 15 and 16, Mr. Logan.
Okay. 15 and 16. And that's Roger Logan.
Yes.
Are you Mr. Logan?
Yes, I am.
All right, Mr. Logan, my name is Judge Lal, and I'd like to remind you of your right to remain silent. Anything you say in open court, the statements can and will be used against you. You have a right to an attorney, and representing you is Mr. McLean.
Okay.
Oh, Miss Vigiletti.
Okay, yes.
All right. So, in 21 CR 5448Y, you were accused of DUI under the influence of alcohol per se, driving under the influence of alcohol less safe, possession of an open alcohol container, and failure to use a turn signal. This is from November 5th, 2019. Your second case, 22 CR 995D, you have a new arrest for driving under the influence of alcohol less safe, failure to report striking a fixed object, and a too fast for conditions charge. And this is from December 14th, 2019. Ms. Vigiletti, how are we proceeding?
Judge, Mr. Logan would like to make a bond request this morning.
All right. You may proceed. Ms. Vigilante, you may proceed.
Yes, Judge, I'm sorry, I'm just pulling up my notes here. So the primary reason for the bond request this morning is that there is a dispute of fact, in particularly on the December charge. I won't get too deep in the facts, but you know, the report does say he hit a slippery spot on the road, hit a tree, and was taken to the hospital with no indication of any sobriety test.
I don't I don't mean to interrupt you. Actually, I do mean to interrupt you.
Sure.
He is in custody because of a failure to appear,
Yes, Judge,
not because of the bond that he received originally, or
Sure.
if he even received one. I don't see a first appearance.
Yes, these are bind over cases, both of these.
Okay,
For the-
so tell me why he should be granted a bond
Yes, of course.
for failure to appear.
So of course, this court would consider the character of his residents in the community. His colleague, Sarah Gabramariam, was going to try to be here. I believe she is in physical therapy right now, but I spoke with her at length and I'm happy to pass along some of what she said as his colleague. She says they work at Keller Williams Realty together. She says he's extremely reliable and has gone way out of his way to teach her a lot about flipping houses out of the kindness of his heart, that she was new to the field and that he's been extraordinarily helpful. Of course, this court also considers employment status. Sarah explained to me on the phone yesterday that even a few months in jail awaiting a hearing could risk losing your entire business when you work in real estate, that not getting back to people is hurting his reputation, he could be losing his client base, and that not paying his monthly dues could result in a revocation of his license. So he really does have a lot to lose by staying here pre-trial. Of course, this court should consider whether he's a danger to the community. I think the best evidence for Mr. Logan not posing a danger to the community is the fact that these charges are 5 years old. You know, he has made some incredibly positive changes in his life in the last 5 years. He has gotten married. His wife lives in Colombia and is out of reach by phone, so could not be here today, but he supports her entire family. I know that there is a failure to appear on this case. Because it is a bind over, I don't have exact details of the date, and I don't have the proof that where the hearing notice went. There's some documents for me missing here that I don't have to explain exactly what happened, but Mr. Logan and I have talked about at length that he would never be one to miss court intentionally. He has so much to lose by missing court, by being in jail. And certainly the last couple of weeks he spent in jail has been lesson learned to be very vigilant for future court dates. Mr. Logan is happy to comply with bond conditions, you know, provide the court updated information just to ensure that we have no incidents moving forward.
So I've heard that he's a man of an upstanding character. I've heard that he's married. I've heard that he's employed and that he's apparently a mentor to others. What I've not heard is why he didn't show up in court.
And because I don't have the date, I'm missing information here. So I don't have any, I don't know when the court date was. I don't know where the notice was sent. So he's telling me he didn't get a notice. And because
All right, let's find out about that. The only address we have on file is a Westlake Drive, Fayetteville. Does he have another address?
Mr. Logan, is that your address?
Yes, that's my address.
I don't have a return to from sender, return to sender, either one of the cases.
I have no idea exactly why I did not receive that notification. There are several others that are in the household. I don't know if maybe that mail was received.
Who else is in the household?
Actually, I care for my father, who's 80 years old and on dialysis, and my mom is there as well. So
you live with your parents? So that's your parents' home?
I'm sorry?
That's your parents' home?
Yes.
And you have a wife in Columbia, what, South Carolina?
My wife's in Columbia, yes.
So you have two homes, a marital home in one state, and you live with your parents to care for them?
No, right now I'm primarily with my parents, assisting them, and I'm planning on moving my wife here.
All right, and you currently are on a $3,000 cash bond. What is the financial problem?
Yeah, the financial problem is I just don't have it. You know, business has been a little bit slow thus far this year. And like I said, I'm trying to maintain 2 households, and I just don't have it.
Okay. On the, I'm trying to see how the bonds have been spread out. So
Your Honor, I
one
can,
second, sir, just 1 second.
Your Honor, I can shed some light on that. It looks
Okay.
like, first of all, the state would object to any bond reduction in this case. There are 2 failure to appears, one in each of his cases, Your Honor. In the first case, he does have a $3,000 cash bond. That's $1,000 on each DUI count, and then $500 on the open container, and then $500 on the failure to use turn signal. He failed to appear at the first jury trial calendar that he was ever scheduled to be on in that case, and that was in August of 2022. A warrant was issued. The case went dormant, which is why he has a cash bond, Judge, because the case went dormant because they couldn't find him. That was in Judge Edie's courtroom. Then this second case, Your Honor, I'm not even showing that the jail has him booked on a warrant for this case, because remember, Your Honor, this case was on last week's calendar, and the state realized midway through, Mr. Logan was actually considering taking a plea. If you'll recall, he wanted some of his probation to be non-reporting because he lives in Colombia part of the time, and you denied that. And in the middle of that conversation, there was the discovery that he does have another DUI. So we reset it to kind of figure that out. On the second DUI, Your Honor, he failed to appear at that first trial calendar as well. That was May, I'm sorry, of 2023. And I don't believe that he has a bond in the jail for that, but that would be a cash bond as well. And that was in Judge Edlin's courtroom. So at this point, what we're arguing over is a $3,000 cash bond. This idea that he's an upstanding citizen, respectfully, Your Honor, he has 14 cycles out of Ohio, 10 cycles out of Georgia, 1 cycle out of Florida. He has 2 open DUIs in this county. He has a DUI that he was just convicted of in Fayette County in February 2024. He has several drug charges. He has another, it looks like what is like a reduction from a DUI in the state of Ohio from 2012.
That's plenty. Thank you, Ms. Desia. All right, Ms. Vigiletti. The reasons to grant him a signature bond are slipping away.
Judge, I'll just reiterate that the things I've told you about who he is are about who he is today. His criminal history is his past. We've talked at length on multiple occasions about how he's made significant changes in the past 5 years, particularly, he got married in 2020, and that had an incredible impact on him. And I would just hate for him to lose all of this great ground that he's gained because he does have a history, because he's sitting in jail pretrial.
Understood, but it seems implausible that he has obtained this great history while at the same time getting in trouble in the law in the last 4 years. So I'm a little perplexed. I'm going to maintain the cash bond in place, and this matter will be scheduled for trial again before Judge Edline. Ms. Grace, both cases should be consolidated with the judge who had the older case, unless Judge Edline has already consolidated both cases. I'm not certain. But if you could reach out to Judge Edie's or Judge Edline's division to see how these cases should be consolidated. Thank you. Bond request is denied.
Bond request.
I understand that, but like when I come back.
Next case.
Did you give me a date for the return to court? I didn't hear that.
Your cases are scheduled with Judge Fred Edie and Judge Susan Edline. Those divisions would have to send you their trial calendar. I do not have their calendars to give you a date.
Okay, thank you.
Thank you.
There we go, Mr. Anderson. We have our positions 1 and 3, Mr. Anderson. Anderson. There we go.
And I can provide some information about Mr. Anderson.
Right. This is Ronald Anderson. Would that be correct?
Yes, ma'am.
All right. So presently, Mr. Ronald Anderson is represented by Ms. Vigiletti, correct?
Yes, Judge.
All right. Mr. Mr. Anderson's case is 24 CR 2012Y and 24 CR 2013Y, in which the former is a simple battery family violence and the latter is a battery family violence. Mr. Anderson, we are going to reset your case to May 9th to address a plea so that your employer may appear and vouch for you. Your employer is not present at this Zoom session. Ms. Allen, did you want to add?
I apologize, Your Honor. I thought we were talking about position 1. The announcement was number 1 and number 3.
Oh, I had Ronald Anderson as position 2 and 3.
Correct. I'm ready to talk about DeMarcus Anderson when the court is ready.
Okay. Are you Mr. Ronald Anderson?
Yes, I'm Ronald Anderson.
Okay. Ms. Vigiletti, we've agreed to reset it to May 9th. Would that still be the process?
Yes, Judge.
All right. So, Mr. Anderson, your attorney has reached out to your employer to show up and vouch for you. So presently, the state's offer was 90 days to begin credit for 15 days. So since they're asking for additional jail time, I'm going to reset your case for your employer to appear so that they can contribute to your arguments of why you should not be sentenced to additional jail time if you decide to accept the offer.
Yes, ma'am.
All right, May 9th at 9 a.m. Thank you. This individual on GPAD 10.1, can we please stop her video until the case that she's interested in is called? Thank you.
Next, we have position number 4, Mr. Baines.
Okay.
Mr. Barnes, I'm sorry.
Mr. Barnes. This is Tariq Jamal Barnes, case number 24 CR 0007938. Mr. Barnes is accused of battery, family violence, criminal trespass causing damage to property, 1 count of obstructing or hindering a person from making an emergency phone call, and 2 counts of cruelty to children, 3rd degree. Mr. Barnes, you have a right to remain silent. Anything that you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one could be appointed to represent you. Presently, we have Mr. Michael McLean, who is ready to confer with you and to explore your legal options. Would you like an opportunity to speak with him?
Yesterday, Your Honor, we spoke and I informed him the state had emailed the district attorney's office regarding a felony charge. And so he is informed of what they are seeking to do. And so he stands by waiting on that result.
Understood. I was actually directing that question to Mr. Barnes. Would you like the public defender's office to represent you?
Yes.
All right. So your attorney is Mr. Michael McLean, and you are on notice now, Mr. Barnes. If you engage in any impolite, disparaging conduct towards Mr. McLean or any attorney with the public defender's office, you will be dealing with me. Do you understand?
Oh, Your Honor, this was not that person.
Oh, it's not? I thought it was. Okay, sorry, Mr. Barnes, you were the wrong person. Sorry about that.
No, he's very polite.
He's very polite. Okay. I thought he was the okay, sorry about that, Mr. Barnes. Who was that person then?
We'll go into chat or
Okay. Forget what I just said. It was meant for somebody else. Thank you.
Sorry.
All right. So Mr. Barnes' case is what we doing then? Are we resetting it to May 9th?
I believe it was reset to May 9th before.
All right. Yeah, I got the notes in 2 different spots. Sorry about that.
No
Okay.
problem.
So, Mr. Barnes, the state has actually requested a transfer of your case to felony court. So we're going to reset to May 9th. At that time, you can decide whether you want to accept an offer from the state, whether the case will be transferred, or whether you'd like to enter a not guilty and further notice the case for trial. Okay, thank you.
Thank you.
This individual with the G-pad, can you start your video and remove your yellow hand signal? G-pad 5. The lady in the white t-shirt.
Can you hear me?
I got to see you. So Miss Grace, send her your start video
I gotta
call.
start the video. Okay. Can you see me
Yeah,
now?
what would you, which case are you wanting to address?
Well, I'm just not coming in because my mom came in on my
What,
son.
who are you? Who are you?
I'm Shakila Williams. I'm saying I just came in because my mom just contacted me for Darion Williams case.
All right.
I'm the
He's already been sentenced, so
but she was saying that you wanted to get me online and they said that they spoke with me. My phone was off yesterday, so
you need to speak to the prosecutor because this was already a plea offer. Ms. Desiano, were you the one who took the plea for?
Yes, Judge, in the middle of the plea, I believe her mother came on and said that the victim doesn't object to the stay away. And then I said that we spoke to the victim and we read her the plea offer and she said that she agreed to it. So it would be surprised for me to hear that she's objecting to the stay away. And you asked if we could get a hold of her.
Okay.
And I believe our victim advocate reached out and now she's on the Zoom.
All right. So, Ms. Williams, please raise your right hand.
hold up, it's my right hand.
All right. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. And what's your name?
It's Shakila Williams.
And what's your son's name?
Darion Williams.
All right. And so he's already been sentenced. He's allowed to have contact with you, but it cannot be any physical or verbal altercations between the two of you. He's
Right.
also required to do a domestic violence program, which is a 26-week program. He's
Okay.
required to do 40 hours of community service. And he is required to stay away from 2389 Connolly Drive and not be in possession of any firearms.
Okay. So how long is that for?
That is for 10 months.
Okay, 10 months. Okay, so how can we get him mental health?
You would need to, while he's on probation, he can go and visit different healthcare providers and see which one he qualifies for.
Okay. Okay.
And 10 Park Place. Downtown Atlanta, 10 Park Place.
Did you hear that, Ms. Williams?
Okay, repeat that again, because I couldn't hear you.
10,
The number
10, just 1 second, Mr. McLean. 10 Park Place is the address that the public defense attorney is mentioning.
Okay. And that's located in Atlanta?
Downtown, pretty much in the middle of all that Georgia State property as they expand their campus.
Okay.
All right.
So-
Anything else, Ms. Williams?
Is he his attorney? That's the attorney?
Yes.
Okay. Could you guys, I just have one concern, only just one, which is he's epilepsy. And
All
so,
right,
like,
now we're getting into private medical information that's being broadcasted to the whole world. So
Okay.
if you want to have a conversation with Mr. McLean, Mr. McLean is going to put his number in the chat.
Okay.
Or if you have a pen and paper, you can write it down now or type it on your iPad.
I can type it on my phone. Let me type it in.
All right, and if you look at the chat, it should be on the chat feature and he will be glad to speak with you.
Okay.
Anything else with regard to the sentence as I've read it?
No, that was all.
All right, then you're free to go after
Okay.
you've gotten Mr. McLean's number.
Okay.
All right, thank you.
Thank you.
Next case at Jail Court iPhone. Or anyone else? No? Jail Court iPhone? No, they left? Okay. Mr. Bartel, are you ready to proceed? Is Miss Falk back yet from meeting?
Not yet, Your Honor.
Okay,
Yeah, good morning, Judge. How are you?
fine, thank you. I guess I'm waiting on Miss Falk before we can begin with our breakout session.
Okay, Your Honor. Judge,
So-
in the courtroom, do we know if they're going to be bringing other people? I haven't
First
heard.
appearances, they're going to get first appearances, folks, but
Yeah.
probably.
Yeah, I can probably, whenever you're ready to start, Judge, I can just move to another location and use my laptop.
All right, whichever you're comfortable with, since the courtroom is empty. But unless they're using it for the next court proceeding, then
They
you
may
definitely
be
need.
bringing some other people.
Okay, But in the meantime, I think I've already gone through the probation calendar with the exception of Ronnie Smith, which was to serve 30 days and then to report to complete the rest of it for 90 days. Okay. So that brings me back to the SAP calendar. I think we've addressed everyone until point 13 and 14, which is Luana Johnson, and she has been released and further notice for trial. Position 15 is 15 and 16, bond modification was denied. The cases are further notice for trial. Position 17 is a plea. 18, Sanders, Deshaun Sanders. Are we waiting on that?
Mr. Sanders is entering a plea of not guilty this morning. I just sent over a waiver of his presence and arraignment.
All right. So Deshaun Sanders will be a waiver of arraignment and further notice for trial. Position 19, Devon Tinson.
Same for Mr. Tinson. He's entering a plea of not guilty this morning and waives his presence and arraignment.
All right. So position 19 is also going to be further notice for trial. 30 is a negotiated plea. 21 is null crossed. 22 is a plea. 23, 24, and 25. Okay, 23, Joseph Williams. What's the announcement?
Waiver.
All right. Joseph Williams is a waiver of arraignment and further notice for trial. And position 24 and 25, Ola Juwan Wilson.
Well, the first week, Your Honor, that was the fellow that seemed rational, and then all of a sudden he was saying insanity when you asked how he pled. Then the next week, I went to him in the jail cell visitation booth, and he says, "I'm so sorry. That was not very nice. I will be good tomorrow." And that was the day he could not, I was told by the deputies that he could not get out from underneath the covers. So yesterday we had a very unsuccessful conversation. We're at wit's end now as to what we should do. Perhaps we should just ask for a psychiatric examination at this point.
He's reset to May 9th. Pending an evaluation request.
Thank you. That's,
okay. All right, that leaves us with that one case that we are holding on to.
Position number 1, Your Honor, I think is the only thing. Miss Vigiletti, I had a question about any documents from 2015 supporting the facts in this case.
All right, and what's the request, Miss Vigiletti?
So all I have in terms of documents is the accusation that just, the charge is giving a false name. So the accusation, of course, just says he did give a false name. And, because this was 9 years ago, he has no memory of what we're talking about. And so I need some, if he's going to take a plea, I would need something else to help him remember what this incident was. I did read the accusation to him and he just has no memory of this incident.
What's the state like to do with this case?
So the offer in this case, in acknowledgement that this gentleman has had an active bench warrant in this case since 2017, and when it was issued by the court, he already had a bench warrant in his 2016 possession of cocaine case. Both bench warrants are in the system. They have different addresses. The last time this gentleman was arrested was in 2014. So when he was arrested most recently, Your Honor, April of 2024, he was arrested on cases from 2024, 2018, 2014, 2015, and 2016. So it makes sense to me that he might not remember the one count of giving false information that resulted in a bench warrant in 2017. So I've provided a copy of the bench warrant. This gentleman hasn't been in touch with the court since his arrest in 2014, hasn't changed his address. I'm not sure what the reason would be to, be away and have multiple warrants on multiple cases at this point. But the accusation is present. I can tell you that the offer is time served and credit for the time that he's been in at this point. And I think this would be the last case that he has holding him. He also already has a bond.
Well, he has a bond in Superior Court. I don't know if.
Judge,
Well, it seems that Ms. Vigiletti's client doesn't want to enter a plea if he doesn't know what he's pleading to, specific facts. Is there anything else besides a bench warrant? Bench warrant really doesn't transmit any.
I have a bench warrant and an accusation right now in Odyssey. I'll have to pull a physical file or go to the clerk's office. Case manager also has no paper documents.
All right. Is the state able to prove this case beyond a reasonable doubt if it goes to trial?
I'd have to pull a physical file and see. I'd have to make a decision about that at another date.
All right. On the, does he have a bond presently, Ms. Vigiletti, on the?
He does.
All right.
Judge, it's a $1,000 surety bond.
I'm going to amend it to a signature bond through the jail. Would you like to reset the case for trial, or would you, because that case is not holding him.
I would be happy to, if any, contextual documents are provided, I would be happy to present those to him and see if he would like to take a plea. If that's what's
all right
possible.
Miss Allen's already sent you the documents. If you want to take a plea, please request the case to be put back on the SCP calendar.
I'm sorry, Judge. The documents Ms. Allen sent me are the ones I already have. It's just the information and the bench warrant. It provides no information about what happened.
All right. You decide, Ms. Vigiletti. I'm giving you $1,000 signature bond through the jail, given the age and the brevity of the state's case at the present time. But if you want to transmit the offer to him, he does have those felony charges holding him in jail. That I cannot control. That only you and, well, he and his other PD can control.
I have no problem, because he is being held without bond on some of his charges, resetting this for a week to see if we can get any further information about what happened here.
Okay, so we reset to May 9th for you to decide either to arraign the case or plea it.
Thank you.
All right, so the only other case I've got left holding out here is position 12, and that is the individual with whom I should have admonished before. Poor man. All right, he must have been completely clueless. Okay. All right. Is the deputy, can you give me a status of Abraham Harris? Is he being brought over? Is there a deputy in courtroom too?
I apologize, Judge. No, there are no deputies here.
All right, we can reset him to May 9th. And hopefully we'll be able to, or Mr. McLean will get a better chance to speak with him. All right?
Your Honor.
Yeah. Who is this?
This is Johnny Hudson.
What
I
case
am
are you here for?
I am the victim in the case of Abraham Harris.
Oh, okay.
And-
Well, he's not in jail. He's not on our Zoom screen. The deputies have not brought him over. He's still in custody on a bond, and he's not accepted a plea offer, and he's not spoken to an attorney. So I'm resetting the case to May 9th. If you want to appear at that time, I'll be glad to address you. But I cannot address you unless he's present as well.
Yes, Your Honor, but if you would, please, Your Honor, let me just say this.
No,
Okay.
I cannot address you unless he's present. But if you do want to speak about your position, you please reach out to the Victim Advocates Division at the Solicitor General's office.
Yes, ma'am, I will.
But that's the reason why I'm not going to address you, is because the defendant's not present.
Okay.
All right, thank you.
All right. Cut me off.
Okay, I think that completes the SAP calendar. Yes, Ms. Vigiletti, Mr. McLean, do we have anyone else on your calendar?
I don't believe so, Your Honor.
All right. In that case, thank you, everyone else, but I'm going to go into a breakout with Mr. Murphy, Ms. Falk, and Mr. Bartel, who's also present, and Ms. Kia Burgess. Anyone else who needs to be in the breakout session, please start your video.
Your Honor, can you put me in the breakout as well?
Well, yep, your video is on. You'll be in the breakout, with the exception of courtroom 2. All right, and with the exception of Krista Meadows.
Okay, Judge.
All right. So courtroom 2 and Krista Meadows are not going to the breakout. The rest of us are. Thank you. Miss Grace, I think we have completed all our cases, so we can close the session. Thank you.
You say you're done, Judge? Everybody.
Done. Yeah.
Thank you. I'm sending over this order Ms. McLeod just sent me.
All right, will do. Thank you, Miss Champion. Thank you, Miss Grace.
Bye-bye.
Bye-bye.
So